morning and welcome to CSIS. My name is Sujay Shivakumar. I'm a senior fellow at CSIS and the director of the Renewing American Innovation Project. The Renewing American Innovation Project was founded about 3 years ago here at CSIS, recognition being that the innovation system of the United States itself is a national security asset, one that has to be cared for with the appropriate policy and funding. Today's we'll be talking about patents, and patents, of course, are critical for innovation. Essentially, they turn ideas into secure property, and this then enables cooperation needed to turn these ideas into products and services that renew our economy and provide new products for the market. It's so fundamental, in fact, that it's enshrined in the U.S. Constitution. Today, the United States' economic and national security rests on its strengths on technology and innovation, and this means that we need an updated system of intellectual property rights for this modern age. To explore this, we are joined by Representative Deborah Ross to examine the role of IP in innovation and geopolitical competition. Following remarks by Representative Ross, Andre Iancu, Senior Advisor to the CSIS Renewing American Innovation Project and a co-founder of this project as well as a former director of the USPTO, will chair a discussion with her and a panel that includes Henry Hadad, Senior Vice President and Deputy General Counsel at Bristol-Myers Squibb, Tom Brown, Senior Legal Director at Dell, and Doug Collins, former House Representative from Georgia and a former ranking member of the House Judiciary Committee. Now, let me introduce to you Representative Ross, who represents the North Carolina 2nd Congressional District that covers Raleigh and the Research Triangle Innovation Hub. She was first elected to Congress in 2021 and is now serving her second term. She serves in the House Judiciary Committee, the House Ethics Committee, and the House Committee on Space, Science, and Technology. She's also a member of the House Democratic Leadership Team, serving as Chief Deputy Whip on the Steering and Policy Committee. So please welcome Deborah Ross. Thank you.
Well, good morning. It is wonderful to be with you this morning, and thank you so much for inviting me to speak with you. I'm excited to join this discussion on intellectual property, U.S. global leadership, and national security. As you've heard, I serve on the Judiciary Committee. In particular, I serve on the Courts and Intellectual Property Subcommittee of the House Judiciary Committee, one of the few subcommittees this Congress that's been doing bipartisan work. Before we get to questions, I want to highlight just a few issues I've been working on and talk briefly about how they pertain to national security and innovation. First, I want to mention a few reforms that I believe would be appropriate at PTAB to ensure we're properly incentivizing innovation. As you all know, PTAB was created through the America Invents Act to provide a more efficient, less costly alternative to district court litigation. However, PTAB is often a difficult venue for small inventors because of the relatively low burden of proof required for patent challengers, the repeated challenges that inventors can face, and the threat of dual challenges in district court. For this reason, small inventors often find themselves subject to an onslaught of litigation from big companies, to the point where it might be more cost-effective to settle than to continue defending a patent. This is not good for innovation. I have a bill with others called the PREVAIL Act, which I introduced with Congressman Buck and Senators Tillis and Coons. It will make various reforms to PTAB to address these issues. It will harmonize the burden of proof at PTAB and district court, requiring clear and convincing evidence to invalidate a patent. It would require challengers to choose between making a challenge in district court or at PTAB to avoid dual litigation. And it would limit serial petitions by requiring challengers to raise all arguments in a single challenge. These reforms, if enacted, would protect legitimate innovators from well-funded patent trolls and ultimately strengthen our patent system to support our country's innovation economy. The second issue I want to discuss briefly, because it's a big issue, is AI. The Judiciary Committee has held multiple events on AI and IP, as has the Science, Space, and Technology Committee. Of course, AI is a new, powerful technology, but we need to quickly develop strong policies for how AI and IP relate if we want to maintain our competitive edge on the world stage. Otherwise, we risk confusing our IP system and not giving due and compensation to creators because they deserve understandable rules and standards to protect the underlying IP. Topics of question regarding AI and IP include whether AI developers should need to license materials used for training, what AI products can be protected with IP, and more. Artificial intelligence is a particularly interesting issue when we consider global competition and national security. We are, of course, in competition with China in the development of AI, and we have huge national security concerns. While American AI developers typically train AI through data available on the internet, China, which has a vast domestic surveillance capability, has significant personal data from its own population that it can use in the development of new technologies. We should not sacrifice our standards to outcompete China when it comes to AI, but we do need to figure out how to make sure we stay on the cutting edge for national security purposes. Finally, I want to highlight a bill that was signed into law last Congress, the Unleashing American Innovators Act. This bill aims to support our innovation economy at the ground level by creating new patent offices with a mission to conduct outreach to underserved populations. All people from all communities deserve the opportunity to see their innovations patented and to profit from their ingenuity. I'm hopeful that as the Unleashing American Innovators Act is implemented, we will see an uptick in patent applications in underserved communities. If we're not fully supporting American innovators, if we leave out entire populations that have not historically had the resources to compete, we risk losing out on their creativity and their contributions to our nation. This is the message that I want to end with. We can best support our national security through strong IP rights and by bringing those rights back to the American people through greater access to the U.S. Patent and Trademark Office's support and services. Thank you, and I look forward to our conversation this morning.
Well, great. Thank you so much for those wonderful remarks. Good to be with you, Congresswoman. I was incredibly encouraged by what you just said, primarily in your overall message that we want to encourage national security, innovation, economic growth through stronger intellectual property rights. Can you explain a little bit that link? Because I don't think a lot of people, both in Congress as well as in the general public, understand this linkage between those things. A lot of people think that innovation just happens because people are brilliant, they're engineers, scientists, they want to create, and then clever ones, after the fact, might get some IP rights without seeing that one is necessary for the other. Can you explain a little bit what that linkage is and what you see in it that maybe others don't?
Well, our founders saw it. And that's why it's enshrined in our Constitution, that we would give for a limited time exclusive rights to intellectual property, so scientific discoveries, also artistic creativity. And the reason for that is to encourage people to devote their lives, to do the very best in terms of research and the arts. And people have to feed their families. They have to make a living. And in our country, we will reward you for that incredible creativity, for investing your intellect and your innovation in doing something extraordinary and sharing it with the public. And I want to emphasize, we don't give these rights forever and ever. They're for short periods of time. And after that time has expired, this intellectual property belongs to everyone, can be used to either produce something more cheaply, produce something else, but for that short period of time, you have the exclusive right to decide how the fruits of your labor will be used.
Just to push back a little bit on that, first of all, I agree with everything, but just to be on the devil's advocate side, some would say, look, you can incentivize creators, allow them to feed their families by compensating them, right? By giving them either prize money or just their regular income from selling the product, etc. Why do you need to prevent others from doing it?
Well, I represent the Research Triangle area, and what I've seen is some people are just innovators. They come up with the wonderful idea. They do something that's extraordinary, but they're not necessarily the person who's going to implement that idea. They're not CEOs or manufacturers or supply chain people. They are creators. And the value of that idea, if they don't get to reap the rewards of it, might be somebody else reaping those rewards. And so we need to make sure that they are able to do that. The other thing is that our country does not invest in creativity in the way that it should. We just passed the CHIPS and Science Act, which is the greatest investment that we've really had in a generation, yet it has not been fully funded. And I represent a number of entities that get grants from NSF, but we're not a country that rewards innovation from the ground up. We're a country that expects you to do it on your own. There's private investment, and the only way that you can reap the reward of that is to be able, again, for a limited period of time, have that exclusive right, and then share that innovation with everyone else.
Now, the country used to, in the past, do a bit more in encouraging and investing in innovation, right? I'm reminded of President Kennedy's speeches, really, but the one famous one at Rice University in the early 60s, committing the nation to land a human being on the moon by the end of that decade, which resulted in a broad-based, all-industry, all-government commitment to at least space innovation and related technologies during that decade. Because frankly, we were spooked a little bit by the Sputnik launch from the Soviets. I feel that we're somewhat missing that ethos in today's world, even though we have equal or greater challenges from another competitor now in China and maybe others on AI, as you've mentioned, so all sorts of other advanced technologies. What can we do? What needs to be done to return to that ethos of the 60s to commit the nation?
Well, I believe we took a giant leap. How's that? We'll use a space analogy with the CHIPS and Science Act. So I don't know if you recall from the last session of Congress, the Senate really approached this as competing with China. But the House approached it in investing in the future. And in the end, we both compete with China. The chips aspect of it is being implemented. We're making sure that we can produce the goods and products that we want to do, that we're not being held hostage to a supply chain issue or a single source of chips, microchips. But the more important thing is, again, investing in the next generation. And the United States has been a leader in innovation, but we have not been intentional about keeping our cutting edge. And we absolutely have got to do that. And the thing that I think is just inspiring is going to labs, going to places where people are coming up with new creative technologies, new creative health systems, biotechnology. There have been generations, but there's a new generation that wants to use their talent, their intellect for the good of this country and this world. And we absolutely have got to invest in them. And I believe at least the science part of the CHIPS and Science Act is a step forward.
Yeah, it's a good example of what can be accomplished, and we have to look at more industries, I think, and figure out what needs to be done in those to incentivize. Speaking of which, let's talk a little bit about the green energy industry. You've done a lot of work developing that for the United States, especially given the district you represent. Can you talk a little bit about what type of innovation and IP protections are needed to further incentivize investment, frankly, from the private sector, but also the public sector into those industries?
So the main thing that's going on with dealing with climate change and finding alternative carbon-free ways of producing electricity is bringing down the cost. So we've had hydropower is really the oldest form of renewable energy that we've had. But we've had some problems with droughts and different ways of regulating that hydropower. Solar came on the scene, but because initially it was more expensive, it wasn't adopted as readily. Now we're seeing utility scale solar. So most of these innovations are ways of reducing the cost of harnessing the wind, hydro, making small modular nuclear reactors. But there has to be an economic incentive to do it, and there has to be an economic incentive to do it not just to say, yes, we can produce this energy, but to show that it's cost effective, that it is reliable, and in the case of things like battery storage, that it's dispatchable, which means that we can use it 24/7. And rewarding that innovation is not only going to expand this industry, but it's going to lead us to a cleaner air, cleaner water, and a better environment for the future.
Yeah, one of the remarkable things about IP, and I think it's a bit counterintuitive to a lot of people, is that IP protection, given the incentives it provides, actually works to lower costs, right? Because it incentivizes more competition, more private industry getting in if there are the rewards out there. And on top of that, it incentivizes collaboration, which is really important. If you're secure in your IP rights and the rule of law, you're more secure collaborating with your colleagues. And that's really important for universities in your district. You know, if they don't have protection, why would they collaborate?
Well, I think they might collaborate just because of the intellectual stimulation of it. But having that protection makes it so that there are rules of the road when you collaborate. What are you licensing? Who is the underlying creator? So what it just gives people an understanding of what the rules are, how best to secure their rights, but also how when they share information, you know, the right person gets the credit for what they do, and whatever they do together, they each can be compensated for.
So let's turn a little bit to the PREVAIL Act, which you talked about in your remarks and introduced with Representative Buck in the House. First of all, at a higher level, how does a bill like that relates to a specific function at the U.S. Patent and Trademark Office, the post-grant proceedings at the PTAB, how does a bill like that actually work to incentivize innovation or to help with national security and other technologies?
So just to be clear about the PREVAIL Act, and I want to give most of the credit to the senators because they were the ones who initially put it together and they've already been having hearings on it, it is taking PTAB, which was a good idea and does good things, and now that we've had the experience with PTAB, making changes once we've seen that small innovators have not benefited as much from PTAB. So it's a good idea to make it quicker and easier to resolve patent disputes. It's a good idea to have it be less expensive. But because the way PTAB is functioning right now, and you might end up in two different venues, district court or before the PTAB, you might have two different standards of proof for defending your patent. That creates just a quagmire for the small inventor. For big people who have plenty of money and plenty of lawyers, it's you can have kind of strategic advantages as opposed to innovative advantages. So the changes that we're recommending are ones that provide more certainty, more protection for true patent holders so that they don't have to constantly defend their patent. Remember, as we've been talking about, this is a right that's limited in time. It's not like you have your patent forever. Well, if you get your patent and then you spend 15 years defending it, then you really don't have the protection that you need in order to reap the rewards of your innovation. So really what the PREVAIL Act does is look at what the unintended consequences were when PTAB was created, try to fix those, and try to rebalance in favor of innovation.
Now, some who like the PTAB quite a bit, and by the way, approximately 80% of the patents that are undergoing PTAB review in IPR or PGR, more than 80% of those are also in parallel district court litigation, which is the dual system that you just referenced. And the petitioners who like the PTAB will say, well, why would you make it more difficult to access the PTAB? Because, you know, if you have invalid patents, the patent office should have the ability to take them out, to invalidate them. So why create a higher burden of proof, which the PREVAIL Act does? Why should you make it more difficult to invalidate invalid patents?
Well, it's really equalizing the burden of proof. And remember, somebody went through the patent process to begin with and got the patent. So I talked a little bit about the American Innovators Act. So many people don't even know how to access the patent process and lose their intellectual property along the way. So getting the patent in the first place is not an easy thing, as you well know. And so if somebody is going to try to take something away when you've already you've done the invention, you've put in the blood, sweat, and tears of getting your patent, it shouldn't be easy to take that away. And again, it's limited in time. So once you get your patent, if you spend all of your time and effort trying to defend it, then we all lose out on that innovation.
Right, and the argument there is, you know, if courts give deference to the original examination in the patent office, why shouldn't the patent office itself give deference to itself? Especially when, speaking as a former director, the patent office rarely makes mistakes, especially between 2018 and 2021. So might as well give deference. Now, some completely on the other side, people who really hate the PTAB and some of those are the smallest of the small inventors, individuals in their garages and so on, and they really dislike the PTAB. Those will say, well, why should you have it at all, right? And why should you give the petitioner the choice to avoid district court and be in the PTAB at all? Why not just put all the faith in our court system and the jury system, which is in the Constitution? So, they would argue that your bill should be amended to effectively eliminate the PTAB, at least if the inventor doesn't want to be there.
Well, what I would say is that those inventors, those very small inventors, are going to have to take the time and spend the resources to defend the patent. And it's much quicker and it's much more cost effective to be in the PTAB. And so while I understand that they may prefer to be in district court, the PTAB is a quicker and more efficient way of dealing with it with people who have a fundamental basis in patent law. However, the bill also requires the choice between PTAB and district court rather than burdening them with having to litigate in both venues.
Yeah. One other thing that your bill does is it has some good governance provisions, which I think there's broad consensus on those. One of them goes to the review by the director, the politically appointed director. And last year, the Supreme Court said that all final decisions from the PTAB on IPRs and PGRs have to be reviewable by the politically appointed director under the Constitution and separation of powers and all of that. And your bill effectively codifies that and provides, good governance procedures for how the director is to review a final decision. Now, some will say that that's uncomfortable. It is what the Supreme Court said, but some will say that it's uncomfortable because it's a quasi-judicial procedure between two private parties, and now you have a political appointee that would make these decisions. What do you think about that and how to slice that issue where you have the constitutional mandate, as the Supreme Court articulated on the one hand, on the other hand, just a general feeling of Americans that judicial decisions should be politically independent, and that's why we have Article III courts.
Well, I couldn't agree with you more, but we have to follow what the Supreme Court has dictated. And that then makes it even more important that we have experienced, thoughtful, and ethical appointees, and that the process for doing that appointment is strongly vetted, and that we have people who really only care about the underlying content and making sure that the law is applied correctly. That doesn't always work. It doesn't always work with all of our judges. But we have to follow what the Supreme Court says and try to find absolutely the best person. I think that the bill enhances our efforts to do that.
Right, and there's transparency issues that the bill addresses, which also there's broad consensus on. Okay, so now dialing back to national security issues and something that a lot of the audience at CSIS and the CSIS organization cares about. Can you talk a little bit about how all these issues, whether it's PREVAIL Act or just IP in general, how does that impact our national security and why the general public should care?
Well, I think when we think about national security, we need to think about it in terms of the things that benefit and protect our security, health, and welfare. And so, yes, national security is our armed forces and protecting our borders, but national security is also making sure that we have ample supply of COVID vaccines if we have a pandemic. And having strong intellectual property is one of the things that made our pharmaceutical industries able to ramp up and produce the vaccines that we needed during the coronavirus pandemic. The same is true, and I alluded to this in my remarks, for AI. We have got to be sure in terms of cybersecurity, in terms of manipulation of our elections, any of these things, they are all matters of national security, that we create the incentives for the best and the brightest to come up with innovation. And again, this innovation is not just out of our universities. It goes back to the American Innovators Act. This innovation can come from people seeing security threats in their areas and coming up with an innovative way of dealing with it. But if we outsource intellectual property to our competitors, we don't have access to it when we need it in times of peril.
Yeah, very well said. And one of the other features of intellectual property is that it encourages public disclosure. Really, patents, copyrights, they are a quid pro quo. We'll give you, the creator, a limited time of protection, and what you give the public in exchange is you're making your invention or your creation public. You're bringing it forward. The word patent means to lay open. And that has all sorts of benefits. Others can improve upon it, and so on. One area within artificial intelligence that has basically no IP protection of this sort is data. So, AI depends on data sets and training models. There is no patent for that, no copyright for that, and companies keep it very secret as a result. No public sharing on anything like that. Any thoughts about, is there any discussion at all, any thoughts about potentially creating a sui generis type of IP right in that area?
We haven't discussed it in our committees. However, Congresswoman Foushee, who represents the other part of the research triangle, and I just had an IP roundtable with tech companies and others, universities, to talk about what we might do to incentivize having data be more open, having people be able to share things in a way where they feel more comfortable, because, again, what IP does depends on the data that it starts with. And there are a lot of concerns about civil rights, about bias, about a wide variety of things. And
privacy.
So, privacy, everything. And so to the extent that we can create incentives to have that data, that input, be as broad and diverse as possible, that's something I think is absolutely worthy of discussion. We did have a brief one hearing in Science, Space, and Technology addressing this issue, but we need to have a larger discussion about it.
Yeah, there's so many interesting things surrounding this, and IP is really critical, as you said, to AI development.
It's also, if you don't mind,
Sure.
It's also very important in the arts. So we had a couple of hearings on this. I've actually introduced another bill, which we didn't talk about, to help working musicians to make sure that in terms of AI training and then, of course, monetizing anything from AI, that if a copyrighted work, and I know we're talking about patents today, is used, that there's licensing, there's compensation, all of those kinds of things. And that's more on the art side.
Yeah, they're very related, these issues. Conceptually, they're very similar. Obviously, in the Constitution, they're in the same clause, copyrights and patents. So, thinking about them together makes a lot of sense. In fact, I think it's imperative, because it would be weird to have a completely different approach as between patents and copyrights, although there are nuances. Okay, so just to draw to an end here, one of the very nice things that I appreciate about IP in Washington is that it's one of the last things that it's not partisan. I think. And hopefully that continues. Obviously, PREVAIL Act is bipartisan, bicameral. With that in mind, despite all the always partisan divides on Capitol Hill, what's the fate of PREVAIL now in the House? Any plans for a hearing, or what are the next steps?
Well, I'm definitely an advocate, and Congressman Buck is as well. And so hopefully we will be able to get a hearing on it. I do think, and I'm a big believer, I've been involved in politics for a while, don't take credit for things that other people did first, that Senator Tillis and Senator Coons have been very successful at working together in the Senate. And I think if they sent the bill over to the House with a very strong bipartisan vote, that would be the impetus that we would need on the House side. Of course, I will advocate for it on the House side, but I think given the current state of the House, and since not that much is getting through anyway, it's better to have that jump start from the Senate side. But we're watching the Senate very, very closely and learning from them. So I'm hoping that it is a very strong bipartisan bill, maybe even a unanimous consent bill, dare we say. But if it is not, we need to be prepared for the arguments against it. And that's something that Congressman Buck and I can learn from as it moves through the Senate.
Excellent. I very much appreciate the optimism. That's great, and all the work you're doing on that front. Any last thoughts before we wrap up?
Well, I just have really enjoyed this conversation. I want you to know that I am committed to working on intellectual property issues. They've been an interest of mine ever since I was in law school, and it's just so exciting to not just work on these issues, but see how important they are in a district like mine, which is a center of innovation. So thank you so much for inviting me to be with you, and I look forward to working with you in the future.
Well, Congresswoman Ross, thank you so much for being here. Thank you so much for your leadership. You really are a tremendous leader when it comes to these IP issues and everything else you're working on. I hope you keep it up, and see you again soon.
Thank you.
Thank you. Okay, great. Welcome back, everybody. And following the conversation with Congresswoman Ross, we have now assembled a stellar panel to dive deeper into the PREVAIL Act and discuss its various provisions, as well as understand the implications to American innovation, competitiveness, and national security. As we've heard Sujay mention at the beginning, let me do a quick introduction of the panelists once again. I will not talk about all of their very lengthy and incredible accomplishments. But first, at my far left is former Congressman Doug Collins, Congressman from Georgia, and he was also the ranking member on the Judiciary Committee during a time when I was the director of the PTO, so we interacted quite a bit back then. He's been a lawyer in private practice and also a member of the military, yes, and continuing to this day. Next to him, Tom Brown, who is the Senior Managing Legal Director at Dell. He leads Dell's intellectual property litigation team, as well as the policy efforts at Dell. Next to him is Henry Hadad, who is Senior Vice President and Deputy General Counsel for Innovation Law at Bristol-Myers Squibb. But most important function within all of that is that he told me that this is the most important function, is that he is the Chief IP Counsel for BMS. Henry has currently also serves on the USPTO's PPAC, and he's also been a board member and president of IPO. Welcome, everybody. Good to see you all. We've all worked together quite a bit in the past. So let me start with you, Congressman, and if you don't mind following up by listening to Congresswoman Ross, maybe you can share your thoughts about the linkage between intellectual property and national security and American competitiveness.
Would love to, and it's good to be here with this panel as well. Also, it's one of the very few times I'm ever introduced as the far left of anybody, so that was sort of interesting, but it is good. No, I think really where we're getting into this, and I think the Congresswoman stated this out in terms, is we're getting into the point where intellectual property, especially in our society today, whether it be a national security issue, not only when we think of our military, but also our businesses and our financial systems, our pharmaceutical systems, our computer systems, they're all interlinked. And when you start to look at how basically the investment economy, that intellectual economy is actually protected, this is where stuff like the PREVAIL Act and others actually come in, because what we're trying to do here is continue what we've had for years, and that is a dominance in protection of intellectual property. And for the United States to ever lose that or step backwards in it will send actually jobs, it'll send intellectual accomplishments overseas. When I was in the Judiciary Committee, one of the biggest issues that we could have is how that tied to just everyday life, not just the everyday life of people coming, their products that they use, but then from my perspective also in the military and still being there, when you look at the rise of China, you look at the rise even of North Korea, you look at Iran, you look at the issues that are going on that we don't normally think about. When you see China in particular, which is in many ways reverse engineered their way to a lot of military superiority or military competitiveness. I'm not willing to go superiority yet with China, but competitiveness, it comes a lot from the things that could be protected here. And I think this is where we've got to make it a clean, pure system, in which I think the PTAB actually started that process down the road. It gained a lot. I was there during the early years on saying, is this going to work? Is it not going to work? Should we give it time? And now there is some time, I think, actually looking back on it to protect national security interests in many ways is allowing our companies to be able to go before a place in which they get protection, but also then are also able to protect those smaller inventors who come up with issues. I'm going to bring one little nugget here, though, that I don't think we talk about enough in Washington. And that is the difference here is we think about cost, and you'll hear a lot about this from these two experts here, of the cost it takes to defend IP, to defend these issues. But I'm going to take it to a different step for the taxpayer. For the defense side of this, and we'll talk specifically national security, whether it be CIA, whether it be defense, whether it be others, when you're taking longer to get to market, when you're taking longer to get products developed, whether it be a plane, whether it be a device, a wearable device for our Army soldiers, our Marines and others on the ground, where they can actually have a better battlefield vision, when you have these kind of just broad spokes that take too long to get to market, then you're actually rising the cost. So it's not just an issue on the inventor side, but it's also an actual problem on the taxpayer side, because if we're starting to see something come up and then it gets delayed in courts, it gets delayed somewhere else or in the innovation process, it adds cost to the federal government on that other side. So it's really a national security issue, but also an economic issue that I think has got to be addressed. And I think this is a good start as we look at it.
Now, Congressman, some will say that IP actually works against those goals that you have just articulated. Some will say that there is too much patent litigation, for example, and that the lawsuits are delaying others from bringing their stuff to the market. What do you say about that?
I think one of the things is if we want to have this larger discussion of patent litigation, and there's a lot out there, is really getting into what you were talking on. And I've seen both sides, the small inventor, the large inventor, the buyers of innovation, which is, it needs to be there because there has to be a market for the product as well, it's a bigger issue, not just in the PTAB, not just in our Article 3 courts, and especially in Article 3 courts, is solving some of these cases before they ever get to the further discovery process. Let's solve them much earlier in the pretrial process. Let's get these things to where you're getting to an answer before we're having to draw out discovery, draw out everything else. So you've got to look at this, but here's the bigger issue of that. For anybody who says that this is not worth protecting, then what is the investment process here? Why is it even for a small inventor? What are they going to do, whether it be in computers or pharma or anything else? Are they going to spend the time knowing that there may not be an outlet for them to actually monetize their results? Now, I'm a capitalist. At the same point, people do this because they love, and I love how Congresswoman Ross actually said, they love the intellectual stimulation. Intellectual stimulation is great. A paycheck is better. Okay, and you have to have both. So there has to be that incentive. So I think that's where it really comes down to. You can't not allow the protection to be there, even if there is a process to get to it. We just got to make it easier for those who want to be a part of it.
Yeah, one of the most important things about IP in general, patents in particular, is it's got to be a balanced system.
Yes.
Both sides have to, be well represented. Otherwise, the system goes out of whack. Okay, so let's turn to the PREVAIL Act in some detail. It's a long bill that addresses various issues at the PTAB. One way to think about it, I think, is to categorize it into three major components. One is harmonization between PTAB actions, IPRs, PGRs, and so on, and district courts. A second category is preventing repetitive proceedings of various sorts. So, do it once, do it right, but don't do it again, kind of thing. And the third major category is good governance. Just different procedural issues addressed. So I want to take each one in turn, if you don't mind. So let's begin with the harmonization process, the harmonization provisions. Tom, let me start with you. One of them is a standing requirement. District courts have a standing requirement. The PTAB currently does not really have a standing requirement. The bill PREVAIL tries to harmonize those and add a standing requirement. That's one of the harmonization provisions. Can you talk a bit about it?
Sure. Thank you. Very nice to be here. Thanks for inviting me. So I want to just step back for a moment because my views on all of these requirements are informed by what we're trying to accomplish. And it is critical to promote innovation. And as you recognize, innovation is about a balance between those who are inventors, who invent new subject material, and the public. And also in there is those who use the inventions in new and important ways to put out real products. And there's overlap. There's substantial overlap. So those like Dell, who are significant patent owners, we are also quote unquote implementers. And oftentimes we innovate when we are implementing. So those are not mutually exclusive categories. But it is critical that there be a balance, as you say. There's been a lot of talk of individual inventors. And if we're talking about not over-indexing in one direction or the other, it's important to recognize that of the 1,351, I think, PTAB proceedings that concluded in 2021, the most recent year for which we have this sort of data, 13 of those involved individual and small inventors. It is nonsensical to me that we should that we should focus so much attention on small inventors and rework a system that has been working well for the benefit of such a small percentage. If we want to protect them, and we should give them more targeted protections. We should have rules that maybe apply specifically to those 13 inventors, those 13 small parties, and we should not throw the baby out with the bathwater, which represents the benefits that we've gotten from the PTAB system. Also, since we're here at CSIS, I want to point out that on the subject of national security, in fiscal year 2022, 56% of issued U.S. patents were granted to foreign companies. Among the top 10 of those was Huawei. So as we work to protect U.S. interests, we just need to be clear that the more we strengthen U.S. patents, the more we strengthen foreign patent owners to the detriment of U.S. innovators, U.S. implementers, and ultimately the U.S. consumer. So on the standing question, the PTO, so just one other point that came up earlier, there was this discussion about whether PTAB proceedings are a quasi-judicial dispute between two parties. I don't think that's right at all. I think PTAB proceedings are a chance for the expert patent office, the experts who first issued the patent, to fix their own mistakes. A private party can bring to the attention of the patent office the fact that a patent or a patent claim, we're not usually talking about full patents. We're talking about one particular description of the private party's property right. Maybe that was poorly drafted. Maybe that just doesn't quite capture what their invention was. By the way, less than 0.004% in fiscal 23 of all live patents were fully invalidated. That means that all claims in the patents were taken away. So the vast majority of time, vast majority of time, nobody loses their patent. Nobody loses their whole patent in a PTAB proceeding. So yes, in terms of standing, it's important that the PTAB be able to perform its public function of making sure that that small percentage of the claims whose validity is being contested should be subject to a second look by the PTAB, and limiting who can raise those concerns with the Patent Office is again a sledgehammer to me for a much narrower problem.
But on that point, why is that? So can you talk a bit about why more than 80% of the patents in IPR already have district court litigation? So what? Those are not going to have a standing issue. Why do you think it's important to allow non-parties, those who are not aggrieved or don't actually have concerns, they're not being sued, right, or threatened? What's the benefit of allowing those entities to challenge?
Sure. So there's a wide range of instances where parties who haven't been sued may validly have concerns about the validity of the patent. The biggest one, from my own perspective, is suppliers. So in the bill as drafted, if we have a component that we include in Dell products and Dell is sued, as we often are, for our use of that component, there's no ability for our supplier to come in and protect us. And conversely, if our own customers are sued for their use of a Dell product, and they're the only ones who are sued, there's no ability for us to come in and protect our customers. So that's the easiest example. And then again, more broadly, if there's a patent that there is a difference in technologies here. So in my own space, we often have patents that appear to cover one thing when they're issued, and then 10, 15 years later, when they're asserted in litigation, the owners are now asserting that they cover some other technology that didn't even exist at the time the patent was issued. And so I understand that there's no standing requirement under the PREVAIL Act if you bring your challenge early within the time frame for what's called a post-grant review. But in my own space, we don't know what the patent owner is going to think that it covers during that time period. And so there is, again, a public interest incentive to allow the public to tell the patent office that this patent actually turns out to be much broader than it thought when it issued it. And from a public policy perspective, there's just no reason to limit who can raise that concern with the patent office.
Henry, let me turn to you on this one. Do you agree with that there is a public interest to allow folks who are not aggrieved in any way to bring challenges in an IPR adversarial process?
Yeah, thanks, Andre, and thanks, Tom, for your response. So first off, let me just say that I'm here providing my own views. I'm not representing Bristol-Myers Squibb, certainly not the PPAC or anyone else. But I have to say they have been informed not just by my experience in the life sciences, which is obviously a very R&D intensive space, but also just seeing the work of innovators across the different technologies, right? Whether it's through IPO or through any other organizations I've worked with, seeing basically the traditional American manufacturers who rely on a robust patent system to justify the significant investments they make in innovation and development. I've also had the opportunity to see the plight of the small inventor who has been litigated into powder by a system which allows repetitive challenges over and over again. Getting to the standing requirement in particular, so there's a reason why our form of the law has developed a standing requirement. The law didn't want judges to have amorphous potential harm being a jumping off board for basically judges having the opportunity to provide advisory opinions on things which don't have a real concrete possibility of causing a challenge to a litigant. So for that reason, they implemented the standing requirement. And the standing requirement actually requires some type of concrete harm or threatened harm going forward. The vast majority of the time, as Andre pointed out, these patents are already in litigation. Clearly, the harm is in existence. But I think when you just take a step back, the idea of having open season on patents is antithetical to the concept of creating quiet title in a property right. A patent, and we're going to get to the standards of proof in a couple of minutes, a patent is basically a presumptive legal property right. And as you create more opportunities to challenge it, particularly by people who don't have a vested interest in the challenge, but rather just want to challenge it maybe because they're funded to challenge, or they have a conceptual problem with the patent system, just creates more opportunities for mischief and undermining that property right in a way that's not going to justify more innovation and certainly investment into that technology.
So, Henry, one of the arguments here is from patient advocacy groups who say that it would benefit the public if they, the patient advocacy group, would be able to bring IPRs and challenge pharmaceutical patents to lower drug prices, for example. Yeah. Thoughts about that and the benefits that they say that would be removed by including a standing provision?
Yeah. So generally speaking, and that's only a segment of advocacy groups, because there's other groups who also recognize that without a robust patent system, there will be no drug discovery in the first place. I think getting back to the life sciences space, we spend the most in R&D spend compared to revenue of any technology, and there's a reason for that. It is incredibly risky. It is incredibly difficult to discover a new drug and then to develop it. You have many, many, many more failures and successes along the way. You're spending billions of dollars, taking 12 years, thousands of people hours over that decade or so to get to an approvable drug. And without a patent system to be that platform for that investment, and also to use the revenue from that period of exclusivity, which is rather limited. It's on average about 13 years, according to a tough study. you will never be able to not only bring the current drugs to market, but to invest in the future generation of drugs. So I do think there's ample opportunities to challenge patents by organizations and individuals who have a vested interest as they're developing new drugs in this space. And that's the system that's worked for many years and continues to work well.
I will point out that Patent Office also has a re-examination proceeding,
Right.
An ex parte re-examination proceeding that anyone can use.
That's right.
And there is no standing requirement for that. Let me turn to the second harmonization provision here that's important, and you mentioned it, Henry, so I'm going to start with you on this one, which is the burden of proof. In the district courts, patents are presumed valid. The district courts presume that the Patent Office did a good job. So to show invalidity, you have to show it by clear and convincing evidence. At the Patent Office, under the America Invents Act, the burden of proof is just preponderance of the evidence. There is no presumption of validity, no deference given by the Patent Office to its own original examination. So PREVAIL would equalize the burdens and require that the post-grant proceedings, IPRs, PGRs, be shown, invalidity be shown in those proceedings by clear and convincing evidence, like in the district court. Can you talk a bit about this, what's it trying to solve for, and is it a good idea?
Yeah, I think it's an excellent idea, and one I think from the very beginning of the AIA was a missed opportunity. So to start with, a patent, as I mentioned before, is a presumptive legal right. And for the history of the American patent system, that presumptive legal right was you have, after going through a hopefully robust examination, which took a number of years and in today's dollars costs thousands of dollars, that you will have a right that warrants investment in, to build a factory, to invest in a new area of technology. And that clear and convincing right, which has been established in the district court, let's use the number, and people vary, 75%. You have to have a 75% chance of showing that a patent is invalid at the district court level. At the Patent Office level, now remember, this is the very office that examined the patent in the first place, is giving no credence to that examination at all, effectively, and basically preponderance is roughly about a 51% chance. That, if you just do the math, that's a significant diminution in the right overall. And that's certainly not the direction we need to go in as a country if we want to invest and incentivize new technologies. So just looking at the property right overall, I think that tells one story. The other piece of it is that one of the justifications for serial or parallel challenges at the PTAB and district court are the different standards of review. And if we could harmonize those standards of review, then we have a fairer playing field for patent holders and more consistency in the approach taken by both the PTAB and the district court judges.
So, Tom, with the different burdens of proof, some argue that there is an opportunity for forum shopping and therefore mischief by the accused infringer, petitioner, and looking for the better forum. Also, there is an argument of potentially inconsistent results. Patent Office and District Court giving different answers to the same validity question. Thoughts about those?
Sure, and I should have started out with a similar comment disclaimer that I'm not speaking on behalf of Dell in any of these comments. These are my own views, likewise informed by my job, but not on behalf of my employer. So let's talk. I want to talk about consistency versus predictability, because this is a question: should the PTAB be consistent with district courts? District courts, a recent study found that district courts are almost 2.5 times more likely to get it wrong, more likely to be reversed on appeal on questions of validity than the PTAB has. We don't want consistency. We don't want the PTAB to be wrong as much as the district court is. As much as the district court is. We want accuracy, and yes, we want predictability. And let's talk briefly about this presumptive legal right. Inventors absolutely should have a vested interest in what they invented. And this PTAB process, at the end of the day, determines more carefully what they actually invented. There's an opportunity, if the claims were written incorrectly, they should get fixed. They can fix it during the PTAB process. They could fix it later in the reissue process. Yes, they should have a vested legal right in their invention. And now the PTAB process is determining what that invention is. So should there be the same standard of proof in the district court and the PTAB? Absolutely not. The district court is a lay judge and a panel of lay jurors, and yes, they should be deferring to the expert agency that issued the patent in the first place by giving it deference, and that deference is represented in the clear and convincing standard. Should a panel of 3 expert judges who are spending vastly more time with the specific language of the claim likewise give deference to the examiner who had very little time comparatively to analyze the claim, much less evidence at his or her disposal, much less, no benefit of an adversarial system? No. The PTAB should fix mistakes where it finds them and then work with the inventor to come up with claims that accurately represent his or her invention.
Congressman, there is a fundamental debate here that Tom touched on briefly about the role of juries in the American legal system. It's in the Constitution twice, really. It's both in the body and in the amendments in the Bill of Rights. But we really are the last country, really, that decides patent issues with a jury system. And some will say, as Tom has alluded to, that they're less accurate, juries are, than the experts in the administration, the career judges. What are your thoughts on that, and how does that play on Capitol Hill, that debate?
Well, I think we've just seen here for the last few minutes very excellently, very good analysis by both sides of what you're dealing with. And here, I'm going to take it a step further. If we deal with judges who may or may not, who are district court judges who deal with everything under the sun in federal court and then have to deal with a patent case in which they, may or may not have knowledge of, and a 1 or 2 clerks who may not have ever seen a patent case in their life, there is an issue here. As someone who comes from the north, actually the circuit that I came from, North Georgia, back in the 70s, late 60s, 70s, was one of the highest patent issued courts in the country. Most people wouldn't think that because you think California, you think other places, pharmaceutical, and you know why? It was the chicken industry. I kid you not. It was the manufacture of poultry and the different mechanical parts that they would get patents for, and it just flooded the court. And the judge at the time, who I became friends with, said, this was the most difficult thing we had to deal with. He said, if you wanted to come in here with a murder case or a conspiracy case, I understood it. He said, you come in here with drawings, we were having to spend so much time, which gave the advocacy for saying that there may be a need for more specialized district court proceedings or an Article III kind of court. I tell you, one place we see this is in China. Actually, I've been to China. I've actually sat with their intellectual property courts, and it takes their courts, which they do, which most people don't realize, they do the vast amount of their work is in-house or in-country, if you would, Chinese companies against Chinese companies. There's the American version and foreign versions there. But they have said that we needed a more specialized court. I think that might be something that may be later on, because there is an issue of, are we getting the proper knowledge in a Article III court with a jury proceeding of people who may or may not understand the issue. But I will take it back. I'm not sure, and many inventors have seen, are they getting a fair shake at the quote experts who have issued a patent and now are coming in without a standard and saying, okay, are these experts actually looking at this from a perspective of, is there a problem here? Are the experts looking at it with a blinded vision of, here's the way we've always done it inside the department? And that's not to be offensive to the department or offensive to the examiners, but it's also one of those things. How many times in life do we actually go out of our office buildings and we see the same things every day? And until somebody all of a sudden moves a chair and you run into it, you don't realize, hey, maybe I should be looking at this. This is why Congress is so difficult in this issue to make people understand, because there is a balance here. And I go back to my first comments, though. These issues need to be more reconciled. They need to be more available, maybe targeted approach, maybe a more broader approach, definitely to have a consistency in what we're looking at, because I think the Act does that. But there's a part of the Act also that is, I think, more important than any, and that is the pulling of money away from this court for experts, that I think putting that money back into getting good quality patents coming out, getting the experts and making sure is something that you may discuss later, but I think that is something that needs to be emphasized more to give the justification to these courts and saying, hey, pick one of these, you'll get a better result.
Actually, the PREVAIL Act does have a provision to allow the Patent Office to make sure it keeps its fees entirely. And frankly, there's $1 billion out there sitting in Treasury that belongs to the PTO, and it still has not been appropriated. So just putting a plug in for that to make sure that gets returned. But anyway, so back to PREVAIL. I will say, as a litigator, people say what you want, as people might say about lay judges and juries, but one thing about them is that they're fresh every single time. As you have indicated, Congressman, they are not, they don't see the same thing over and over again. They bring an open mind. They really try to do a good job. And there is tremendous wisdom in the constitutional system that we have. That has to be balanced, of course, by the appropriate results. Turning to the second big category, repetitive proceedings. There are various provisions that PREVAIL talks about. First and foremost is the single forum provision. So can you talk a bit about that, Henry? Let's start with you on that.
Sure. I think right from the outset of the PTAB proceedings, the single largest complaint that I heard and that we experienced was the opportunity for multiple bites at the apple of challenging a patent. And it's bad enough for a large company like Bristol-Myers Squibb or Dell to deal with these type of things because it injects considerable uncertainty into the robustness of that right. You may believe in your patent, but you hit a patent enough times in court or before a different fact finder at the PTAB, and you never know what's going to happen. There's always a degree of uncertainty, right? So I think that was a real problem for the larger entities involved in the innovation ecosystem. It was absolutely devastating for the smaller entities and the small inventor groups who are impacted by PTAB, because at the end of the day, and Tom mentioned some statistics about the number of patents affected in small inventors before the PTAB. That doesn't count the number of small inventors who are no longer seeking patents, which we've heard, or are not trying to enforce their patents because ultimately they believe it's a road to ruin. And that's a real problem, and I've heard firsthand from those either testifying or speaking about these issues going in their experience. But turning to the single forum. So a few years back, there was a case, the Cetera case, where basically a party would have to, if they're bringing a petition, would have to stipulate that they're going to attack the patent in one forum or another forum. And what this is effectively doing is codifying that approach. I personally cannot see how this prejudices a petitioner. They have their opportunity to choose their forum, and they can choose either the PTAB or the district court. They just can't choose both. And I will stop there and turn it back to you, Andre.
Yeah, and I will note that they have to choose one, but there is no penalty unless the PTAB institutes, right? So if they choose to file a petition and the PTAB does not institute, they can still keep going in the district court.
And if new bases of challenge come up, they can, again, go back to the PTAB.
Correct.
Yeah.
But if the PTAB does institute on a particular claim, then they can no longer maintain the same arguments in district court. What's wrong with that, Tom?
Okay, so I'm going to re-stress my caveat before that this is my own views. Are duplicative proceedings wasteful? Absolutely. Should you be litigating at the same time on the same issues in the district court and in the PTAB? No. So what's the solution? Recall that district courts are 2.5 times more likely to be reversed than the PTAB. The solution is clearly that you should be litigating in the place that gets it right. Okay. So you should, the PTAB, in my view, is the right forum. What does that mean about what happens in the district court? The solution is very simple. When there's litigation in the district court, when there's litigation in the PTAB that may affect what happens in the district court proceedings should be stayed. Why is that critical? First of all, if you don't stay the district court proceedings, then you have the same problem. You're still litigating in 2-4 at the same time. It's not going to be any cheaper for anybody just because a couple of issues may be removed from the district court proceedings and moved over to the PTAB. You're still spending the same money at the same time. It's incredibly expensive. I can say that from personal experience. Second, you cannot have district court proceedings that determine infringement proceed in parallel with PTAB proceedings that determine validity because they interact with each other. The patent owner is going to make arguments, both sides are going to make arguments in the PTAB proceedings that influence how they view the scope of the claims. If the patent owner views the claims narrowly in the PTAB in order to get the claims past validity challenges, and then broadly in the district court in order to get a finding of infringement, that's a problem. The district court proceedings should be stayed until the PTAB proceedings are done, so that the district court can use the proceedings in the PTAB to understand better what the claims mean. And also, by the way, the patent owner may and should have a full and fair opportunity to amend the claims in the PTAB.
So Tom, just to follow up on that, I mean, whether you stay a district court case or you allow the petitioner to choose the PTAB or the district court, to me, it seems like you're making that decision for the petitioner. I don't see why you wouldn't want to allow the petitioner to make that decision.
The petitioner should make the decision, but the problem is that it's the patent owner who may sue in a district or may just refuse to stipulate remember, most of these cases are in the context of a pre-existing district court litigation. So it's the patent owner that files suit. The petitioner then may challenge the claims. At that point, yeah, if the patent owner ought to agree or the court ought to rule or it should be mandatory that the pre-existing district court case get paused to take into account what happens at the PTAB.
Now, the reality is that in many, many cases that already happens. There are many, many districts, many judges that will stay depending on facts and circumstances. But what you're suggesting, if I hear you correctly, Tom, is that it should be mandatory and there should be no discretion for the district judge to manage their own docket.
I mean, no discretion. No, I don't think that. I mean, I think that if there's real hardship on the part of the patent owner, or if there's unusual circumstances where, for example, if the patent owner, again, off the record as much as we can be, but if the patent owner is seeking a preliminary injunction, and if there's real imminent harm that the patent owner may have as a result of the infringement, maybe preliminary injunction proceedings can go on. But the notion that you should have a full-fledged trial while you're having a full-fledged PTAB proceeding, even if the issues are different, doesn't make sense to me.
How about staying the PTAB while the district court is going in some cases?
The problem with that is that the analysis of validity in the district court case is going to be truncated because there's so many issues involved in the district court proceeding. And so the record will be much more developed if you allow the PTAB to go first. And also, if you stay the PTAB proceeding, then that will... I haven't thought it through entirely, but there's logistical challenges on when do you get to enforce the judgment, right? You can't enforce a judgment that comes out of the district court proceeding if the PTAB proceedings haven't even had a chance to.
Congressman?
I want to jump in here because from a political standpoint, this is what we're trying, and I go back, I came into Congress right after this was passed with Lamar Smith, and so we felt a lot of this, and one of my biggest arguments in protecting this was the first few years we didn't have enough knowledge in seeing, these different issues you have. The one issue that I would take with Tom here is basically your application of this would be different, I think, than the understanding of many members at the time, that there was one or the other. And there's a lower cost and then you had probably, what I just heard you saying, and I'm just curious here as we discuss this, you're giving preference to the PTAB proceedings as the authoritative voice. Because if you stay the district court and then have to come back to see whatever happens at the PTAB, you're sort of binding the court to a non-Article 3 body, it's a different, and I understand what you're saying, don't get me wrong, but it is interesting here. From your perspective, everything should just go through PTAB.
The reason why there should be one or the other is to make for a faster, more effective, cheaper solution. That solution is the PTAB, as the AIA recognized. And so, yes, it should be the PTAB.
So then you're keeping people out of the Article 3. I think this is the political argument that we're going to have on Capitol Hill that we're going to see, play out here, is in essence, you're making a quasi-Article 3 court out of the PTAB. And I think that's something that will never fly for many political, just on the argument basis, whether it may be. And the curious question I would have in this, and I think you made some great points here, is what were they reversed on? That's a curious question for me. They may be more reversed, but were they reversed on actual issues of patent law, or were they actually reversed on which we've seen a Supreme Court that frankly hasn't got it right either on deciding some of these issues, or were they reversed on technical issues in these as opposed to it?
So these were validity questions, and we can dive into the
No, this is cool. I mean, but I think you see the
steps.
political issue here, and I'm not attacking. I'm just saying this is the political issue that we've dealt with for a number of years now on trying to find a balance, as you just said just a second ago. Find a lane and deal with that lane. And if you think the PTAB is better, you'll go to the PTAB. If you think the Article 3 court is better, you'll go to the Article 3 court.
I remember when the AIA was being debated, and the goal of the PTAB was for very clear situations where a patent should not have been granted on, and that's why it was limited, at least for IPRs. Remember, IPRs can be brought anytime, as opposed to PGRs right after grant. Was that it was based on patents or printed publications, because you were supposed to look on the face of, oh yeah, this probably shouldn't have been granted, these claims, we need to amend this or that. It has turned into something quite different, which is a primary basis for invalidating patents based on a limited record, based on limited witnesses, on an inability to test the veracity of both the fact witnesses and the experts through cross-examination. These are all very serious parts of the American jurisprudence system which protect the property holder. And if you believe that a patent is a significant property right that warrants investment and is the incentive for innovation, you believe in robust protections for it. If you believe that it's an inconvenience, then you want a political body that will go in and look at it and at a very lower standard and knock it out based on a limited evidentiary record. And I think there's a fundamental schism in certain views of certain technologies and certain innovation ecosystem sectors.
Okay, so we could keep going on this one for quite some time. It really does go to some fundamental principles of American jurisprudence. Who gets to choose the forum, which historically is the claimant, the plaintiff, the viability of independent courts, the viability of a jury system, how it applies and interacts with complex technical issues in patent cases. This one issue. It's a remarkable microcosm of all these arguments, and I think hopefully we'll get the debate it deserves on Capitol Hill.
Can I bring this back to national security?
Yeah.
And this goes back to the very issue here in dealing with national security, whether it be especially when you're dealing with new weapon systems. Let's take it to the hypersonic system. We're taking it to the AI, even if you want to go into that. When you're looking at battlefield technology, the question here would become is what is the best, most efficient route to protect, I do believe, is part of the bundle of sticks, going back to that a property right, that patent is a right. It is something that needs to be protected. Can it be challenged? Of course, it can be challenged. But you've got to find the best route to do that, the most cost-effective way. And what we're seeing in some of our developments, we're seeing some of that move out of the country because of some of these issues on the best and the multiple bites at the apple, which I don't think, frankly, the Invents Act had any desire for this to be multiple bites at the apple. It just didn't appear that way in the legal text. But from a national security perspective, are we, again, raising costs? Are we limiting who we are able to not only contract with, but go to a supply chain? Are we having to supply more, getting from a national security perspective? Are we having to source more foreign investment? Are we having to source more foreign companies that would be integrated into our national security network? Such as things from security monitoring systems, data monitoring systems. These are kind of things that need to be adjudicated early enough to keep the costs down. So that's the security aspect that the Hill has to look at. Whether way you go which way or the other is finding the best solution.
And just recall that when you over-index on the side of patent protection, you're protecting Huawei. Huawei is consistently one of the top 10 patentees. Foreign entities are 56% of U.S. patent grants.
And then the issue has become is there a way that we look at this from a perspective of you're over-indexing, whether you over-index or not, is where the patent system comes from and who is the inventor coming from, and are you then taking it away from ours, which I think there could be things put in for American-based companies that can protect that patent system in a different way as well. Huawei has a different issue from a national security perspective in the fact of the connection to the Chinese government. So I think could be a whole different aspect. But a good point. I mean,
I'd also like to add from a perspective of economic competitiveness.
Mm-hmm.
I would say that over the past 2 decades, between certain court decisions and these procedural challenges at the PTAB, we've created a less stable patent system. And we are, as a country, I would say, a knowledge economy, one that has been steeped in some of the greatest innovations in the history of the world over the past 200 some odd years. If we develop innovations here and then allow them to be exported internationally and then sold back in our country with a weak patent system that really can't be enforced, or it's so difficult to enforce that you really are hobbled by that, then we're not doing our country a service. We're actually exporting jobs and exporting technology internationally. And that can't be good for our long-term perspective.
So, given the time, let's just turn very quickly to the third bucket, which is just good governance type provisions, and I think there is likely more consensus on those. But let's just test it out. One of them is codifying the director review from Arthrex and how the PTO has implemented that. There's a code of conduct for PTAB judges. And just very quickly, so on those two, do people think that those are good ideas or not? Tom?
Absolutely. I think that requiring the director to have responsibility for the PTAB decisions really does go hand in hand and emphasize that it is a PTO obligation to issue good patents. It's not just a debate. It's not just a dispute between private parties. The PTO is an active participant, and the director should be responsible for those decisions.
Henry?
I'm fine with both provisions. I would say that if I had a choice personally, I would allow 146 appeals to district court after a PTAB decision, which would also solve the Arthrex problem. But as far as I'm concerned, the provision is fine.
Any concern with the political appointee that comes and goes, and sometimes you don't have one because they're interim between administrations when we don't have a political appointee? Any concerns with
why the 146 action seems to be maybe a slightly better solution? You know, when you come to like claim construction or any type of policy change, a patent is a 20-year right for many industries. And to have the property right, wax and wane depending on who's appointed in the office doesn't seem to make sense. And it's not particularly encouraging for investment. So I think having more stability in terms of rules are very important. I mean, as I think the Congresswoman said earlier, I think her perspective was you're going to get a high level of appointee there that's going to try to adhere to the standards, and hopefully that will be the case.
Another governance procedure provision is the idea that judges who rule on institutions shall not also participate in the merits decision, in the final written decision. Thoughts on that, Tom?
Yeah, there's no other area of law where we say that someone who's invested substantial time and effort into evaluating the merits of a particular dispute should then go away and not participate in further evaluations. It's a waste of time to say that it's a waste of time to disqualify those who are the most knowledgeable about a dispute from further participation. Again, if you want to ensure, if you're concerned about bias or you're concerned about accuracy, that's what the appellate process is for. So I think that there's no reason, and it's counterproductive.
Well, at the ITC, Tom, right, the institution decision at the ITC is not made by the ALJ that's actually running the case, right?
Okay. One other area.
Okay, as an example. But it ultimately does come back to the Commission at the end after the ALJ's decision. Congressman, while these issues are not partisan, there's still obviously, as we see on this panel itself, there are serious divisions, not along part of your ideological lines, but along different lines. Given that, and you've experienced that for sure while you were there, what are the chances here that something like this moves in Congress?
I think there's not partisan. I do think there's ideological differences, and I think that would come in a little bit in the sense of what you believe in. You brought it up well, you know, the difference in a trusting an Article III court as opposed to a bureaucratic board or an appointed board. I mean, there's just ideological differences in the function of government. I think on the Hill, this is the unfortunate part. If we've talked about Article III courts being sometimes not the most technologically placed for these hearings. Well, I'm also going to say that the U.S. Senate and the United States House is probably not the overwhelmingly best place to have some of these agreements, not because the individual members don't want to, but I've spent years doing this. These two amazing folks have spent, you as well, have spent amazing years doing this. This is not a 5-minute elevator speech. This is not something you can explain going up and down. Well, here's why I'm voting for this. Because there's legitimate. I mean, I've listened to the two arguments here today, and I've had some pretty good opinions about it and been, you know, very favorable to what's been said. This is where it becomes a concern for me every time we open this up on the Hill, is trying to find members who will actually be able to take an ownership or a leadership role in this. You found this in the Senate. I think we found that a little bit in the House now. And then getting it to the point where we can explain it to members and it not be down. I'm not as favorable as that this would be on the easy path in the House. I think the Senate may be a little bit easier on this issue. There'll be some discussion, but I think they can get it out if they can get over some other stuff. The House Judiciary Committee right now, I think the best thing they could do is start having some hearings about it. The best thing they could do is begin to have the process of discussing it. I don't see that happening quickly, but hopefully within the next, by spring, if we can see this move a little bit on both sides, having the discussions, it has a possibility. Because here's the biggest issue. We've got to make, I've always said this about intellectual property, we've got to get it out of the realm of theoretical. These two guys are great. It's theoretical. But average people and members of Congress are not theoretical. They're practical. How does this affect Joe and if you have a small inventor in your district, he doesn't care if it's 0.0004% of the people who get that, because it's the inventor in my district who votes for me. And so, and if you're Congressman Ross, you're in the research triangle, you have the bigger issues. So I think what we've got to start doing is making this argument with members who go to their districts or go to leadership and say, this affects our economy. This affects, as we're sitting here, national security. You make those arguments, then you move this forward. You get the details, you're losing it.
On that note, last thoughts. Let's start with you, Henry.
I personally support the PREVAIL Act. I think it's an important step to clarifying the role of administrative agencies in adjudicating the property right. And I would hope that over the course of the next year, we have hearings at the House level, certainly more hearings in the Senate, and that bill advances. I mean, taking just a step back, and based on my observation, I think it's an important step in making sure that this property right is stable enough and predictable enough to warrant the innovation and investment that historically it has and created the greatest innovations the world has seen.
Tom?
I think that there are important concerns that underlie the PREVAIL Act that ought to be addressed in a balanced way. If the small inventors are concerned about their property rights being taken away from them, then let's address that problem. If there's concerns about duplicative proceedings, let's address that problem in a balanced way. But I don't think that the PREVAIL Act is a balanced bill.
And finally, Congressman, you get the last word.
Well, I think that, I do think this is the right step. I think the PREVAIL Act is something that can work. And this is the reason for a good, robust legislative process. If there is concerns, it could be adapted, could be tweaked just a little bit. I think that's the reason. And it has become more and more a concern in bills such as intellectual property sphere, and I'll just use that not just in this area as well, has become more and more concerning that we do not have that robust debate among members who understand it, bringing in experts to understand it. But I think the step here in the PREVAIL Act actually goes back to the original intent of the Innovators Act. There may be some things we'll disagree upon, but remember, the intent was to make a clearer, more precise process that protects all entities involved and do it at a less cost. That's the issue we got to look at.
Well, thank you all, and I think the challenge will be to continue to explain the nuances of these very complicated issues. You know, we've had an hour here, but we can keep going for a very long time. We just scratched the surface. So on the one hand, explaining the nuances and trying to get them right and appropriately balanced, while at the same time really understanding the ultimate impact on national competitiveness, national security, the economy and jobs, across the United States for not just this bill, but the intellectual property system at large. And being able to do both of those things, the details and the bigger picture, I think is critically important. And I think you all managed to do that well today. Thank you all very much. It's been an honor to be with you.
Appreciate it. Thank you.